The History of the Supreme Court by Brookhead. The Supreme Court was established in 1789 under Article 3 of the Constitution. The Supreme Court is special because it is the only court that was created under the Constitution of the United States. The Supreme Court is the highest court in the United States. It stands as the final entity to uphold all laws and liberties under the Constitution and laws of the United States. Currently, the Supreme Court has 9 justices. There is 1 Chief Justice, and the remaining 8 are Associate Justices. Though this has not been the case for some time, it has not always been this way. When the Supreme Court was established in 1789, and through the passing of Congress of the Judiciary Act, the Supreme Court became the central role of upholding all laws. Originally, there were 6 total justices. This number has varied throughout our history, but since the mid-1900s, that number has consistently been held at 9. Justices are chosen by the President of the United States. Where the term separation of powers comes into play is that even though the President can appoint any justice he or she would like, the U.S. Senate has to confirm that appointment. Once a justice is appointed, they have that seat for life, unless they are impeached. The process for impeachment is something like a 2-step process. First, the claim has to be submitted to the House of Representatives. The House must find evidence that is applicable for impeachment and come to a majority vote. From there, it will go to trial in the Senate. One of the most influential periods of the Supreme Court was during the time Justice John Marshall was serving at the Supreme Court as Chief Justice. You should recognize most of these cases during this time. One of those landmark cases are Marbury v. Madison of 1803, which allowed the Supreme Court to overturn laws that were unconstitutional. This is what we know now as judicial review. Some of the other relevant cases that you may be familiar with are in regards to interstate commerce, like McCulloch v. Maryland of 1819, which granted Congress the power to create a national bank, and Gibbons v. Ogden of 1824, which gave Congress the ability to regulate interstate commerce. The first woman to be appointed to the Supreme Court was Sarah Day O'Connor. President Ronald Reagan nominated her for the position of Associate Justice in 1981 and made history as the first woman to serve on the Supreme Court. One important case, which was an attempt to reverse the Roe v. Wade decision in regards to abortions, was the Planned Parenthood v. Casey case, which the court upheld the previous court's decision. The first African American to serve as a Supreme Court Justice was Thurgood Marshall. President Lyndon Johnson nominated him for the position in 1967 and remained on the court until 1991. Thurgood Marshall had a successful career before he ever served on the court. One case that gave him a lot of success was arguing for the desegregation of schools in Brown v. the Board of Education.